Good afternoon, good Erev Shabbos. This is Gabriel Jackson. Welcome to BJC Mitzvah Day, number 58, using the Sefer HaChinuch. A Mitzvah Day keeps your soul on its way. Parshas Mishpatim, the second book, Shemos, lots of mitzvahs in Parshas Mishpatim, and this mitzvah is definitely a long one, so we might take 3, 4, 5 parts to get through this one. The obligation upon the Beis Din, the court, to judge cases of civil litigation, says the pasuk, for every matter of liability, whether involving an ox, a donkey, a sheep, or a garment, regarding any lost item about which he says, this is it, to the court shall come both their claims. Whomever the court finds guilty shall pay double to his fellow. The verse that forms the basis for this mitzvah is stated in the context of an unpaid custodian. See the mitzvah we just learned, 57. Oral tradition, however, teaches that the obligation upon the court to adjudicate pertains to all cases of monetary litigation, not only to the case of a custodian. We are commanded to judge cases involving the laws of a plaintiff and defendant. That is to say, we are obligated to conduct legal proceedings in accordance with the laws of the Torah on behalf of anyone who puts forth a monetary claim against his fellow regarding any issue, whether the plaintiff claims that he loaned the defendant money, or that he entrusted a deposit with him for safekeeping, or that the defendant stole from him, or retained his money, or extorted from him. We are so commanded, as it is stated in Exodus, this Parsha Mishpatim, quote, for every matter of liability, etc., by which he says, this is it, to the court shall come both their claims. The specific case addressed by the verse is one in which the defendant claims, this is it. In this case, the Torah requires the defendant to take an oath. The Chinuch explains the case. The explanation of the phrase, this is it, as transmitted to us by the sages, is that under biblical law, an oath is not taken by the defendant based solely on the plaintiff's claim, unless the defendant admits liability to a portion of the loan amount for which he is being sued. But if he says the matter never occurred, i.e., I never took such a loan from you, or he admits that he took the loan, but he says, I've returned everything, thus denying the plaintiff's claim in its entirety, then whether he makes these claims in regard to a loan, or even in regard to a deposit, he is exempt from taking an oath under biblical law. The Chinuch has explained that the total denial of any monetary claim, even one concerning a deposit, need not be confirmed by an oath. He now provides a source for this rule. It is in connection with this rule of total denial that the sages of blessed memory said in the Gemara in Bava Kama that a mixture of passages is written here. For when the phrase, this is it, is written, it is written with respect to a loan. That is to say, it teaches a rule concerning the type of claim typical of a loan, which is the claim of, I have paid you in full, or the claim of, the matter never occurred. When a defendant sets forth such loan-like counterclaims, even in the context of a deposit, he need not corroborate his position with an oath. Only a claim of partial admission, where he admits part of the claim and denies part, must be corroborated with an oath. Okay, we'll learn more about this later, after Shabbos. Thanks for listening. Sponsor your mitzvah, or to be part of our high club, click the link below. And once again, dedicated to our holy idea of soldiers. Have a good Shabbos.